In the late 1990s, workers from the St. Louis Circuit Court and Missouri State Archives made an amazing discovery in the Civil Courts building in downtown St. Louis. Buried among hundreds of boxes were papers yellow with age and still covered in coal dust from 2 centuries ago. While they didn't look like much on the outside, these documents revealed a history lesson beyond any historian's wildest imagination. A written account of what life was like for a slave in St. Louis. These court cases describe fears of being beaten or literally sold down the river to a harsher life. Tales of families torn apart but still determined to be free.
Hello, I'm Sharon Stevens. Thank you so much for joining us for today's program. Our focus today is on the struggles that African Americans faced to find freedom in a 19th century America that enslaved them. One avenue available to some was to file a freedom suit. These freedom suits, largely unknown to most, came to light in St. Louis when discovered in the records of the St. Louis Circuit Court. Now, to help us understand today's topic, we're being joined by 2 of the nation's premier experts on freedom suits. First, I'm happy to welcome Kelly Kennington, who is a professor of history at Auburn University and author of In the Shadow of Dred Scott, St. Louis Freedom Suits and the Legal Culture of Slavery in Antebellum America. And we're also being joined by David Konig, professor of law and emeritus professor of history at Washington University in St. Louis, and one of the driving forces behind the St. Louis Freedom Suits Legal Encoding Project. First of all, thank you both for joining us. Let's talk a little bit about 19th century St. Louis. What were conditions like for slaves here? Either one, if you can start.
Do you want to take that one?
St. Louis was a unique city in the United States, which is one reason why there were so many freedom suits. St. Louis sits at the confluence of of major rivers, the Ohio. The Ohio was south of St. Louis, but the Missouri and the Mississippi. It also was surrounded by free territory on several sides, to the north, to the east, and for a while to the west, which meant that it was a cosmopolitan city, an inland city that brought people from many different areas of the country, and it also brought African Americans to a spot where they met others similarly situated. They met free blacks who worked on the river, who brought with them an awareness of what it was like to be free, and who explained to them what it was like to be free, taught them that there were courts where they could possibly enter actions to gain their freedom. So you have that going on as well. In addition, it's deeply split in its white population among pro and anti-slavery forces. When William Greenleaf Eliot founded Washington University, and he came from Boston, he said he was astonished at the depth of feeling on each side of the question. He had never seen pro-slavery people quite so ardent in the support, and he had never seen anti-slavery people, except for a few exceptions, so adamantly opposed to slavery. So what St. Louis provided is a context of conflict, a confluence of conflicting forces that led to the courthouse steps.
Okay. What about you, Kelly?
I call St. Louis a microcosm of the country because you have all of these different groups of people from different areas at that time coming to the city. And I think the urban environment of St. Louis is an important element here too, because you have enslaved people and free people of color interacting in the city streets on a regular basis, giving them that access to legal knowledge and allowing them to learn about their right, in some cases, to sue for freedom. But David's absolutely right, too, that the surrounding area being free territory does form the basis for the majority of these cases. And that comes from the doctrine of once free, always free. Once you've traveled or lived in free territory, you are not legally going to return to slavery. And so that's what a lot of these cases are about. And so St. Louis's location so close to free territory is really key to the number of suits that we see here.
We're going to just right at this minute, before I get back to you, Kelly, with a question. Fine. We've got a video about called Once Free. We want to show that.
Okay.
One of those changes came in 1825 when the Missouri Supreme Court set the precedent of once free, always free.
The most popular way of gaining freedom through litigation of a freedom suit in the courts, in the circuit court in St. Louis, was through the doctrine once free, always free. That is to say, if a person had been free at any point in his or her life, at birth or by manumission later on in life, or by residence, legal residence in a free territory, which is distinct from being a fugitive in free territory. That is to say, having resided in on free soil by virtue of the fact that one's owner had taken one there, the enslaved person became free.
Well, the case of Winnie versus Whitesides established the Missouri precedent that slaves who had been transported and resided in a free territory were thereby free. So the once a free person, always a free person doctrine came from this Missouri case. Now, Winnie claimed that because she had been transported by her masters from North Carolina through Illinois, a free state, to Missouri, she was thereby a free person by virtue of her residence for a time in Illinois. So what she did was she sued as a pauper, meaning sued as a poor person. So she was given a state counsel to take her case. And she was ultimately successful based on the sequence of residence rationale.
Let's talk a little bit about what does the information you found tell us about how a suit was filed and then how it, proceeded to trial or wherever. What does this tell us?
Well, you have to tease out. In fact, what becomes clear after looking at hundreds of these cases is that there's a variety among them. And we see that the courts approach these in different ways. One of the most fascinating discoveries was to see how the names of the petitioners were entered in the records. It's quite shocking to see the clerk of the court enter the name of an enslaved African-American woman and after her name identify her as a free person of color.
What do you mean?
Well, in other words, not an enslaved person, that the court recognized that, or gave the benefit of the doubt, at least in presenting the evidence to the jury, that the clerk at least believed this person had a claim to freedom. Mm-hmm. So when one looks at the records and one sees the procedures that are followed, the tricks that are used by slave owners to defeat these cases, one gets quite a bit of insight into the way a society treats its people.
Okay. We are going to, at this point, take a couple of student questions. Here's a question. So how did a slave find a lawyer to file and try his case? Good question.
Well, the way the process worked is when an enslaved person approached the court and presented their reasons for bringing suit, the court actually appoints an attorney for them in most cases. So in most cases, that attorney only enters the case when they've been appointed. Now, we do have some examples where an enslaved person is able to access an attorney and bring that attorney with them to sue. Initially, they don't have to have that appointment. But most cases, that's how it happens, is that they're able to approach the court and then the court is going to appoint that attorney.
And it's a mixed bag, of course. It's because it brings in people who have the full range of opinions about race and slavery. There's some lawyers who do not believe in racial equality, but they do not believe in slavery. There are some lawyers who take the case because even if they're opposed to freedom suits, this is part of their lawyer's oath to do. So it's a mixed bag of attorneys, but there are certainly those who sympathize with their clients in these efforts and bring to the courtroom their best efforts to battle the kind of clever defenses that slave owners often bring to court.
Okay.
Can I add
Yes, of course.
So one of the things that I found so interesting is how significant the lawyers' efforts could be to the success of the case, right? So in some cases, lawyers go to extraordinary efforts to win the case. They take on personal expenses and travel outside of St. Louis to take depositions. They sometimes even put up the enslaved person in their home. I have at least one case where that happens for at least a period of time. But on the flip side of that, you have attorneys that don't show up in court when they're supposed to, and the case gets dismissed, and that's the end of the trial. So the range of efforts that we see put forward by these attorneys is so interesting, and I think really important to whether the success or failure of the cases.
Yeah, Kelly's brought up a very good point about how these cases proceeded, because these were tried by a jury, and a jury of white male property holders. Absolutely. Were making these decisions. And what they had to be convinced was proof, factual proof, that at some point the petitioner had enjoyed freedom. And as Kelly points out, sometimes this meant taking depositions in Illinois or Kentucky for presentation to be read in court.
That could prolong the case too.
It certainly does. It certainly does, but it adds importance to it. In fact, there's one case, a very unusual case, where a lawyer snuck in testimony by an African-American witness, which isn't supposed to happen, but the court accepted it.
Okay, we've got another question coming up. And question is, did slaves face retaliation when they filed a suit?
Yes, absolutely. I'll take that one at least to start. We have instances, in multiple instances, where the defendant in the case actually sells that person away from St. Louis. Now, the statute says that they're not supposed to do that, but as we know, not everyone follows the dictates of the statute, and so we have examples where they are sold outside of St. Louis and they're not able to prosecute their case because they're not there. We also have instances, in one case I'm thinking of, where excuse me, where a defendant actually has the woman do all kinds of dangerous work, and she claims that that's as a result or a retaliation for bringing suit. So they do absolutely face retaliation.
So you really had to be kind of brave
Absolutely.
to file a suit in the first place.
There is no question that the people that bring these cases don't do so lightly. They know what's at stake. They know the dangers and the risks involved, and I think that they're processing that. Not everyone that could bring a suit does, and that's because it was incredibly dangerous, and it did take enormous bravery to bring these cases, and the fact that we see so many people doing that, I think, is really significant.
Okay.
I think we really have to give credit to these petitioners
who
underwent extreme pressure, prejudice, violence, and so on. There's a wonderful resource for this, a St. Louis woman by the name of Lucy Delaney, who published her autobiography called From Darkness Comes the Light, which includes her freedom suit as well. And Lucy spent time in jail in protective custody so that her owner, or putative owner, did not do exactly what Kelly says was always a threat hanging over their heads.
Okay. Speaking of individuals, we have a story coming up on video.
Okay.
Great.
My story begins when my mother, Polly, was captured into slavery. It was a dismal night in the month of September. Polly, with 4 other colored persons, were kidnapped. After being securely bound and gagged, were put into a skiff and carried across the Mississippi River to the city of St. Louis. The Negroes were brought out and placed in a line so that the buyers could examine their good points at leisure. Major Berry was immediately attracted by the bright and alert appearance of Polly, and at once negotiated with the trader, paid the price agreed upon, and started for home to present his wife with this flesh and blood commodity which money could so easily procure in our vaunted land of freedom. After that, my mother registered a solemn vow that her children should not continue in slavery all their lives, and that we must get our freedom whenever the chance offered.
Now, having seen that, Let me ask, are there other individual stories we might be able to talk about?
Yes, one of the stories I find most interesting is the case of Thornton Kinney, who sues based on he was born free in Virginia to a Native American descended mother, and he worked for years on steamboats on the Ohio and Mississippi River. He travels for 5 years to Liberia. He migrates to Liberia and then returns, goes back to working on the river, and he's captured. And he's imprisoned, put in a New Orleans slave pen for sale. And then everyone who came to buy him, he says, I'm free. And so no one's able, he's not able to be sold. And he escapes from the slave pen out of a window, goes back to working on the Mississippi River. He's eventually recaptured and brought to trial in St. Louis, where brought to a jail in St. Louis, where he is able to sue for his freedom. And that's where we get this very rich story of his life. And he is married to a free black woman in St. Louis. And this was in the 1850s, so this is after Dred and Harriet Scott have filed their suit, but not after the final decision in their case. But unfortunately, his case is dismissed in 1855 because he doesn't put up the financial resources to sue, and that's when one of the major legal changes that we see happening in the statutes is in 1845, enslaved people are no longer allowed to sue as a pauper or as a poor person like we've been talking about. That's a shift we see there. And from that point on, they have to have some kind of financial resource or access to some sort of financial resource or a community member who's willing to put up money to guarantee their suits. And Thornton Kinney at that point in 1855 is no longer able to do that.
Okay. Did you want to add anything
well,
to that?
I think Kelly points out in her book a very significant fact, and that is that the majority of petitioners were women seeking their freedom. And there's a very simple reason for that, that by law, and this is contrary to English common law, the status of a child follows the status of its mother. So a child born to a free woman is free, a child born to a slave woman is a slave. So that it was imperative for women, sort of like Mrs. Dred Scott, Harriet Scott, and I think this is a very important part of the Dred Scott case, to bring litigation to show that when her children were born, she was already entitled to freedom under the statutes of the time. And I think it's very clear that she did not want her daughters to grow up as slaves.
Okay. We have another student question, and we'll ask that now. Were freedom suits also allowed in other states? Was Missouri the place where they happened the most?
They were absolutely allowed in every state that had slavery had freedom suits, and there were statutes allowing these cases to be brought in other places, as well as the statute that we've been talking about in Missouri, or the statutes I should say, because they do get renewed and changed a bit over the years. Missouri is not the place that they happen the most, although if you look at the percentages of the population of enslaved people here in Missouri, and certainly in St. Louis, it's a significant number. But you see large numbers in both Louisiana and in Virginia. And there are cases in Tennessee and South Carolina, even Alabama has a few. So there are, I found them in absolutely every state that had slavery.
Mm-hmm. I would think Georgia as well. Yeah. Mm-hmm. Okay.
The statute was, I guess the first one enacted was in Virginia, and it was pretty much copied in other states.
Mm-hmm. Okay. And we do have another student question.
Oh, okay.
I wasn't sure if we did, but now we do. How frequently were the freedom suits successful? Did most of them fail? David, I'm going to...
Well, actually, Kelly has a better answer. Because
Okay, all right.
she's got
You'll
an
defer to Kelly.
appendix in her book, and she's got it
Yes.
down to the exact numbers.
So I double checked the numbers. I got a little heads up we might get a question like this, and 38% of them were successful in my findings. And that does not mean that the other 62%, I'm doing the math in my head, failed. We have a whole category of cases that were unknown, where we don't know what happened to them. And so I think in some of those cases, I know in some of those cases that the people are able to make other arrangements and eventually do become free. So although the number of successful freedom suits, by looking strictly at the verdicts in the cases, is less than 50%, I would argue that the number is actually higher in terms of people that are able to become free later. And bringing that suit, I believe, is a significant element of making that arrangement, because you're essentially forcing the hand of the slaveholder to say, I'm either going to take you through this legal process, or we can make some other kind of deal outside of that, where you'll free me, I'll work for you for a couple more years, and then you're going to go and free me, or I'm going to sue you again. And so we have examples of that, where they're sort of using those out-of-court dealings and arrangements to become free. But in terms of the verdicts of the freedom suits in St. Louis, 38% I can confirm were emancipated through the courts.
In some ways, it might be surprising to some that even 38% was accepted. I think that's quite a number.
Oh, it is. It really is, because not everyone had the access to witness testimony, to evidence, as David was talking about, to confirm their freedom. And so some of those cases lost because they just couldn't prove it in court. And so, I do think 38% is a significant number.
Okay. We have a follow-up question, I think, for you. Did the other states mentioned by Kelly use the same kind of legal rationale to find slaves actually free, or was it different in different states?
We see lots of different arguments being presented, and there are other arguments in St. Louis as well, rather than just that once free, always free doctrine. That is the majority of the cases, but you also have people making arguments about their ancestry. So if you can prove that you're of Native American ancestry, by this point Native American slavery is outlawed in Missouri. But you also see things like people being kidnapped and sold into slavery, and they sue for their freedom based on that. If they're able to establish that they were living as free prior to their kidnapping. You see in Louisiana, there's a handful of cases of people taken to France. And again, similar doctrine, once free, always free, because there's no slavery, no legal slavery in France at the time. And so they go back to Louisiana and they sue for their freedom based on that same doctrine. So there are some similar cases to what we see in Missouri, but there are a whole range of types of arguments. We have people who were freed through a prior manumission document, or freed in the will of one of their slaveholders when they die, and that they're able to use that to establish their freedom. There's people that make arrangements, like I was talking about a minute ago, saying, I'll serve for the next 5 years and then I'm going to be free. And when those arrangements break down, it often shows up in court. And now it doesn't often go in their favor. I will say that the statutes don't really support those kinds of contracts because they don't recognize enslaved people as having that sort of legal standing. But you see a really broad range of arguments being presented, and most states don't have quite as many based on the same kind of residence in free territory argument that you see in Missouri. So that's what I think, one of the things I think makes St. Louis's cases so unique is because there are so overwhelming numbers. Something like it's over 200 of the cases present that argument.
Right. Okay. Now, the era of freedom suits comes to a close, does it not, Kelly, as we move to the Dred Scott case. How did his case get to the Supreme Court, and what was their rationale for their decision?
So Dred Scott, Dred and his wife Harriet, sue initially in 1846 in the St. Louis Circuit Court. And they win their case at the local level. And then it's appealed to the Missouri State Supreme Court, and that's where you get the shift in the doctrine, saying, I believe the quote is something like, "Times are not now what they once were." In other words, the political climate has changed so dramatically that they're no longer going to be freeing people based on this doctrine of once free, always free. And then with support from local families, they're able to, them being Dred and Harriet, are able to appeal all the way to the United States Supreme Court. And at that point, the United States Supreme Court denies jurisdiction. I mean, that's the decision, right? But they go on to, in several concurring opinions, discuss at length the future of African Americans, enslaved and free, in the country. And that's where Dred Scott's case becomes so important, because that's where you have Justice Taney saying that African Americans have no rights, no right to sue in federal court, and that has, as you might imagine, enormous repercussions for the ability of people to sue for freedom in St. Louis and elsewhere.
And why do people still talk about this today?
Oh, that's a great question.
Well, it's a bombshell of a case. It's a bombshell of a case because as the case made its way through the courts from 1846, as Kelly points out, when the case began, to its final determination in 1856 and 1857, much changed. And by the time it got to the Supreme Court, the focus had narrowed, not just on whether Congress had the right to bar slavery in the territories, which was one major bombshell, but the other fact that did Dred Scott have standing to sue? Could he have a day in court? Now, we as Americans say everyone should have their day in court. And what Tawny was saying, basically, is that African Americans could never have their day in court to sue as citizens of the United States, entitled to the same legal standing that a white person would have. Abraham Lincoln, who in 1858 was running for the Senate in Illinois, the famous Lincoln-Douglas debates, raised this case in his debate speeches. And he made it very clear that this was not to be accepted. He made a speech actually a little earlier than that where he said, well, now we're hearing that it's the Negro who has no rights. Next, it will be the German immigrant who has no rights. Next, it will be the Catholic who has no rights. And basically, he's asking the rhetorical question, where will it stop? It must stop now. So it becomes a vitally important issue in the election, and he loses in the Senate race, but it becomes a vitally important issue in the presidential election of 1860, where it becomes clear, he says, we are going to be either we cannot be half slave and half free.
Mm-hmm. We have another question that we want to go to at this time. How have these records changed your understanding, of slave life in antebellum America? How do these primary sources make a difference? David, I think you can take that.
They bring these people to life. I think that's the most important thing that we have here. We have an X mark on the petition brought by the person seeking his or her freedom. So-and-so, Dred Scott, his mark is on the petition for freedom. And to read about their lives, their being uprooted, change of owners, and so on, shows you a side of slavery that we often don't think about. You know, we're aware of the brutality of the day-to-day life of slavery, but this brings clearly home the point that your life could change overnight by the death of an owner, a sale, or something like that.
Mm-hmm. And when you find a situation, you mentioned something about sometimes people were kidnapped into slavery. So you're free, and somebody kidnaps you, and suddenly you're a slave. You know, is there any record of what happened to the people who kidnapped them? I mean, that's a crime.
Yeah, I mean, it is a crime, and we do see some very few examples. And I'm trying to think if I have any examples from St. Louis where people are prosecuted for kidnapping. I don't think there are, but we don't have a lot. A lot of the criminal records have not survived from that time period. But the most famous example of this is Solomon Northup's 12 Years a Slave, which is a recent, made very famous narrative written by a man who was living as free in New York. He's kidnapped. He's sold into slavery in Louisiana, and he sues for his freedom. I mean, he essentially, with the assistance of some family friends, he's able to sue and win his freedom. And they do prosecute the people that stole him from New York, that took his freedom, but they're not successful ultimately. That outcome, and I feel like even in places where we do see these prosecutions. If they're convicted at all, the punishment is often very light, a fine, a few years in jail. Right. It's nothing on the order of what.
The knuckles.
Exactly, and that's because the court system is controlled by, powerful, oftentimes white slaveholders in these slaveholding states, and so. The deck is really stacked against both enslaved and free black people at this time.
Okay. We've got a question for David coming up from one of the students. How are the digital records organized? Can we search by case, by name, and what can we find?
They are organized chronologically plaintiff or petitioner, defendant. They are eminently searchable. There are functions online to search particular names and outcomes. So we wanted it to be user-friendly. The whole idea was to bring this to light and to make it useful. And I would urge people not just to start with Kelly's book, which is marvelous, but then just go and read these cases. See the handwriting, see the way people talked, and so on. But to get back to the question, that they are easily searchable by owner and by the name of the petitioner and the attorney.
It's breathtaking to see kind of the amount of the not only the digitization of the records, but the transcription of the records, and every time I turn around, there's something else that's available. So there's a lot of really hard work going on here to make this story again come to light, and so I really encourage people to use it because I find it endlessly fascinating.
Very good. Thank you so much. We thank you both very much for joining us. It's been enlightening. And our thanks as well to the Missouri Humanities Council for their financial support of today's program, and to each of you for joining us today. Now, if you're interested in learning more about freedom suits, we invite you to now watch ATC's Emmy-winning documentary, Seeking Freedom. Bye-bye.